Welcome to our concluding lecture. In our previous 3 lectures, we discussed that the law of tort is a very important branch of traditional laws to tackle the problem of environmental pollution. And we also discussed the role of mental element in determination of tortious liability and the difference between the law of tort and crime when it comes to the mental element. And please also remember that if I do something wrongful, the fact that I do it with a good intention doesn't make the original act lawful. You understand what I am saying? Suppose if I am committing robbery for the purpose of feeding orphans, my intention may be lawful, but from the point of view of a fellow who got robbed by me, he will think that he had suffered damage in pursuant of an unlawful act, and he will naturally have a right under law to enforce his rights. And the intention again is a very, very funny thing. What is going to be in my mind at the time when I did an act is something which will be very difficult for others to figure out. Usually, intention is ascertained by the acts that I performed prior to the commission of the act, during the commission of the act, and after the commission of the act. If I make a reasonable analysis of these 3 categories, prior, during, after the commission of act, it may be reasonably possible for you to ascertain what is my intention. Please also remember that the torts, nuisance and negligence, there are certain general defenses and special defenses. Act of third party is a good defense. Statutory authority is a good defense. Volunty non fit injuria is a good defense. Volunty non fit injuria means consent to an injury will not give rise to a cause of action. Okay, for example, recently when during the IPL match, Chris Gayle knocked a 6. Okay, that 6 landed on the face of a kid. And the kid had to be hospitalized, some teeth had to be removed, nose was broken. Now the question is, can the father of the kid maintain a successful cause of action against Chris Gayle and the Royal Challengers Bangalore, for whom Chris Gayle played? This will be a classic situation of volunty non fit injuria. Consent can be either express or implied. When I go buy a ticket, okay, and go to a cricket stadium, I go there only to see these guys cracking sixes and boundaries, okay. It may be a different game if the boundaries and sixes were cracked by a player of the team that you did not want to win, but still you are going there only to watch this very specific act. The guy didn't even think of suing either Chris Gayle or Royal Challengers Bangalore. Even if he had sued, the management would have taken volunty non fit injuria as a defense. In other words, for negligence and nuisance, there are certain general and specific defenses, right? This is a serious problem. You can escape the negligence case by pleading that you had exercised due care and diligence, and notwithstanding that it happened, so it becomes an inevitable accident. You can escape a nuisance claim by establishing that you had a statutory authority or the damage caused by novus actus interveniences, which means act of an unconnected third party over whom the dependent had no control. He can escape that actually. then he can plead reasonable use of the land. Okay, so he can escape all these things actually. So in this case, there are two important doctrines which are important. One is unusually sensitive plaintiff. This is a case of Robinson versus Skillwork. It is an 1889 Chancery Division case. Two people had their property. One person was in the higher floor. The other person on the bottom floor used that premises as a godown. In that godown, he stored some packing paper. What you call as, we call it as a cocky paper, you know. The kids in olden days used to use it for the purpose of making a wrapper. But that guy there up was using the premises for a chemical warehouse. He was using a lot of burners and all to maintain temperature, etc., etc. And the heat got down to the bottom premises, which was used as a warehouse for storing the paper. Because of the heat, the person below suffered damages. He naturally sued. But it was pointed out by the defendant that normally, if we had stored the other things, nothing would have happened. But he stored a good which was particularly susceptible to heat. In other words, the plaintiff in this case is an unusually sensitive plaintiff. Normal people would not have suffered damages. For example, I give a friendly punch in your stomach, in the region of your liver. I don't know that you had cirrhosis and enlargement of your liver. The friendly punch would have caused some pain, but it wouldn't have killed. Okay? But because this guy had cirrhosis of liver, he died. Can I be prosecuted for murder or negligent manslaughter? In this case, the doctrine of unusually sensitive plaintiff was established. That is, if the original act is not illegal, okay, a friendly punch is always okay, whether it is legal, illegal, we'll have to. Again, it is not illegal under criminal law, it would be illegal under the tort law. Okay. So that was what was exactly applied in the Emmett versus Hollywood Silver Fox Company. Okay. He was doing something legal and the other fellow was doing something illegal. Both were doing something legal. And if the neighboring guy, the Hollywood Fox farm, had used it for the purpose of raising a vegetable garden or a camel farm, nothing would have happened. But because he was raising a fox farm, okay, he suffered damages. So if the original act is illegal, it is not a defense for the defendant to say it caused more damage than what it is anticipated. And the other theory is Eggshell skull theory. Eggshell skull theory means probably I give a knock on your head. Okay. Actually, as a student, I had suffered this misfortune several times. Each time a teacher wants to discipline a kid, a knock on the head, right? But some kids have what I call as a cephalodisability. They will have a skull which is not strong enough. Skull is the strongest part in your skeleton, okay? The cranial plates have been so strongly intertwined with each other because it houses the brain, okay? And simple external injury should not harm your brain. So in the normal course, if there is going to be a knock on your head, nothing should happen to your skull. But not knowing to the plaintiff, the defendant suffered a particular disability where his skull was not any more stronger than an eggshell. What will happen if you knock on an eggshell? The shell will break. So, Here, if the dependent is an eggshell skilled person, okay, it wouldn't have suffered damages. So all these questions come, and it is possible for the dependent to avail many of the statutory defenses. Okay. Defenses which are recognized under law of tort. In these circumstances, the case of Ryland versus Fletcher was decided. A person wanted to construct a water reservoir. He engaged independent contractors to dig this water reservoir. The independent contractors had the necessary manpower, technical qualification to do the job. So therefore, the dependent had exercised due care and diligence. And under law, I am not responsible for the acts of my independent contractor. I am responsible for the acts of my servants if they perform this act in the course of this contract of employment. This is called as a vicarious responsibility. But there is no vicarious responsibility for the acts of an independent contractor, and that is the law of tort. Now, this independent contractor, when he was constructing a shaft, when he was constructing the reservoir, he found that the adjoining land was used as a mine. Okay. And there were tubes. And these tubes were noticed when the reservoir was dug. And the independent contractor felt that because it has been filled with so much of earth, it might, in the normal course, be able to withstand the pressure even when the water is stored. But apparently the independent contractor has made a mistake. When the water reservoir was filled, due to the water pressure, the earth in the tube or the shafts gave away. The water flooded from the reservoir to the nearby mine. And the plaintiff sued the mine owner. The defendant contended, look here, there is no negligence. I had an independent contractor. It is his fault. Take money from him and leave me out. In this case, Justice Blackburn proposed what is known as a strict liability. Strict liability is a departure from the seminal principle, fault is the basis of liability. For me to be held responsible, there must be some fault on my part. Okay, there is no fault. If there is a fault on the part of the independent contractor. So, take the money from the independent contractor and I am not responsible. Notwithstanding the argument which would have normally succeeded when you consider the general status of law, the court propounded what is known as a strict liability. In this case, he said, non-natural use of the land. When a person collects something which was not naturally there, and if the collected thing escapes, and if somebody suffers damage due to the escape, notwithstanding the fact that he had exercised due care and diligence, notwithstanding the fact that there is no fault on the part of the person who caused the damage, the person will be held strictly responsible. So, 1860, there is a departure. Fault need not be the basis of liability. If you use our land for a non-natural purpose, and if you collect something which was not originally there, and if the collected thing escapes, you will be strictly responsible. You will not have any defenses. And both under law of negligence and nuisance, there is always an element of fact. So in strict liability, for the first time, we introduced what is known as a no-fault liability. Now, actually, in another 120 years, the strict liability evolved into absolute liability, about which we will discuss in our next lecture. Thank you.